English legal shorthand, 100 words per minute dictation. Ready? Start. It was further submitted that in any case, the evidence of an eyewitness has to be of sterling quality. Stop. The trial court itself found inconsistencies and omissions in the evidence of Suraj (PW4) and Amol (PW5), and yet, it believed their version, while convicting the said accused persons. Stop. On the quality of evidence expected from an eyewitness, reliance was placed on the judgment of the Supreme Court in the case of Vadi Velu and another versus State of Madras (AIR 1957), capital SC 614 . Stop. It was submitted that three categories of witnesses were classified in the said judgment, that is, wholly reliable, wholly unreliable, and neither wholly reliable nor wholly unreliable. Stop. The said judgment laid down that in the third category of witnesses, the court has to be circumspect and it must look for corroboration in material particulars. Stop. Relying on the observations made in the said judgment, it was submitted that evidence of Suraj (PW4) and Amol (PW5) ought to have been discarded. It was further submitted that there was no independent witness examined by the prosecution, and even the punch witnesses were the friends of the deceased person. Stop. It was further submitted that crucial witnesses were not examined by the prosecution, including one, Ajay Pawar, who was claimed to be accompanying Sachin Kadam (PW6) when the incident took place, and Gorakh and Saurabh, who accompanied Suraj (PW4) and Amol (PW5), while taking the deceased Nikhil to the hospital. Stop. The deceased was supposed to have been taken by these four persons in the Maruti car of Gorakh, and yet he was not examined and the car was also not seized. Stop. The prosecution also failed to examine Chetan, who accompanied Amol (PW5) to the hospital, and similarly, failed to examine Saurabh, who had accompanied Suraj (PW4) to the civil hospital, despite the fact that the names of these persons were recorded in the injury certificate issued to the injured eyewitnesses. Stop. The recovery of weapons of assault was disbelieved and the ballistic report was negative, and yet the trial court convicted the said appellants. It was further submitted that the evidence of the witnesses clearly established that the deceased as well as the purported eyewitnesses had enmity against the accused persons. Stop. In fact, Amol (PW4) was an accused in an FIR registered in the year 2016, wherein Arif (A1) was the victim. Stop. This indicated that the accused persons were falsely implicated. Stop. In this context, it was significant that while Suraj PW4 was found to be fit to give his statement in the civil hospital at 11:50 pm, his statement was recorded after more than 4 hours at 4:30 am by the police, which led to registration of the FIR. Stop.